Every detail matters in the courtroom. Every perspective demands fairness. Know your legal protections and pursue genuine justice.
Vivian Benjamin was a licensed nurse.
ICE, Immigration and Customs Enforcement, identification and proof of legal status.
I am a United States citizen and a licensed nurse. My ID is in that card.
A United States citizen born in Houston, Texas, a decade at one of the most respected pediatric hospitals in the country. Her identification was in her wallet, in the car, less than an arm's length from where she stood. They did not let her get it. The H-E-B Marketplace parking lot on Kirby Drive was just beginning to thin out at 4:15 on a Thursday afternoon, the kind of late summer Houston heat that does not merely warm but presses, the asphalt soft and shimmering, the air thick and carrying the scent of fresh tortillas drifting from the store entrance, and the faint suggestion of charcoal smoke somewhere beyond the lot's edge. Shopping carts rattled in loose arcs across the concrete. A mother near the entrance was trying to fold a stroller with one hand. Ordinary Thursday noise. Vivian Benjamin was loading the last of her grocery bags into the open trunk of her car, her navy blue scrubs carrying the full weight of a day shift, the particular exhaustion that lives not in the muscles, but somewhere deeper, the fatigue of sustained attention and sustained care. Her stethoscope hung from the cup holder inside the vehicle, looped there the way she always left it, a quiet and unremarkable piece of the landscape of her daily life. Her 8-year-old son James was in the back seat asking with some urgency whether they had bought the kind of chips with the green lid. Her 6-year-old daughter Jasmine was already listing everything she intended to eat for dinner, in order, starting with dessert. It was a Thursday like the dozens of Thursdays before it. She had not noticed the unmarked SUV parked 2 rows over. She noticed it the moment 3 doors opened at once. 3 ICE agents in tactical vests crossed the lot toward her in tight formation, body cameras already rolling, hands resting near their belts with the relaxed readiness of people who had already made their decision before they reached her bumper. The Immigration and Customs Enforcement patches on their vests caught the late afternoon sun with each step. They spread at the edges, a spacing Vivian clocked instantly, without deliberate thought, the way experienced nurses clock a change in a patient's breathing pattern before they can name what changed. That stop would become the most consequential errand in the history of the Southern District of Texas federal courts. If you're ready to see institutional racism taken down, hit that like button and drop a comment telling me where you're watching from. First time here? Subscribe right now, because tomorrow's story of the wrong people getting crossed is one you will not want to miss. And let me know in the comments whether you're enjoying this story. Lead agent Derek Lang reached her bumper first. His partners, agents Marcus Reed and Tyler Quinn, spread wide behind him, flanking her vehicle with the quiet efficiency of a movement rehearsed until it required no communication between them. The formation was designed to leave no direction unaccounted for. It was designed for something dangerous. 10 years of emergency nursing had given Vivian Benjamin a particular kind of fluency, the ability to read escalation before it announced itself, to assess a room and know where the pressure was building before it broke. She had developed that fluency in pediatric emergency departments, where the difference between a child who was about to crash and one who was merely ill could live in a single shift in skin color, a slight change in the quality of a cry, a detail that required complete attention to catch. She read what was crossing the parking lot toward her in the same way. Federal agents, immigration enforcement, moving in containment formation, hands near belts, body cameras already running, a decision already made. She kept loading groceries, slow movements, palms visible, every motion deliberate and legible. Lang's voice carried across the lot noise without inflection flat and rehearsed with the specific emptiness of a sentence repeated so many times it had long since shed its original meaning. He identified himself and the agency. He stated that they were conducting a compliance check. He said he needed to see identification and proof of legal status. Vivian straightened, the last bag still in her grip. She gestured slowly, carefully, toward the open car door, every movement calibrated so that there could be no ambiguity about her intent and no excuse for misreading it. She was a licensed Texas nurse, a United States citizen, Vivian Renee Benjamin. Her identification was in her wallet, inside the vehicle, and she would retrieve it slowly, with her hands visible, right now. Lang did not move aside. He did not acknowledge what she had said. His follow-up question concerned whether she had documentation on her person, on her body, in her hands, right now. Something rose in her chest that was not fear. It was older than fear and more precise, the recognition that lands in the body of a black woman who has spent a decade performing excellence in rooms that expected her to be unremarkable, and who has just watched a federal agent hear her credentials and respond as though she had said nothing at all. She had loaded groceries in this lot 100 times. She had never been stopped. The difference was the agents. The difference was her. The difference was a calculation she was not responsible for having made, and she understood it with a cold and absolute clarity. In the back seat, James had stopped talking about chips. Jasmine had gone quiet mid-sentence, her dinner list abandoned. Children read the air the way animals do, not the words, but the charge beneath them. Vivian kept her hands visible. She explained, again with measured patience, that she was a nurse and a citizen, that her identification was in the vehicle, that she would retrieve it now without sudden movement. Agent Derek Lang stepped forward. What followed took fewer than 30 seconds and required no further conversation. His hand closed around her wrist. The motion was practiced, not brutal in the way that leaves obvious marks, but mechanical and absolute in a way that left no room for response. Her arm was brought behind her back with the efficiency of a procedure repeated until it became reflex, and the handcuffs were applied in 4 measured clicks, while James's voice cracked through the backseat window in a sound that Vivian would carry long after the morning of the verdict. The specific cry of a child who does not understand what is happening, but understands that it is wrong. 6-year-old Jasmine dropped her backpack and pressed both palms flat against the car window, reaching. Vivian's voice did not break. She spoke clearly, levelly, for the rolling body cameras and for the phones already appearing in the hands of bystanders at the edge of the lot. She stated that she was unarmed, that she was a licensed nurse, that there was no reasonable suspicion for this stop, that what was being done to her was unconstitutional. No one from the ICE team responded. A young woman in an HEB apron was already moving across the asphalt toward the children as Vivian was walked to the rear door of the SUV and loaded inside, her wrists set against the steel. The trunk of her car still open behind them, grocery bags scattered across the shimmering lot in the late Houston afternoon. Through the tinted rear window, she watched James climb halfway out of the back seat, watched Jasmine turn her face into the store employee's shoulder. Then the vehicle moved. Inside the SUV, the agents talked as though she were not there. That was the second error they made that afternoon, and by a significant margin, the more consequential one. What Vivian Benjamin heard in the minutes that followed, spoken in the front seats with the casual ease of a conversation that had been had many times without consequence, was not complaint or bravado. It was operational language, comfortable, habitual. Agent Lang's voice carried a low, matter-of-fact frustration about monthly numbers, not the word quota, but a phrase about making the numbers work, about certain neighborhoods being more productive for compliance operations, about the kind of demographic distribution that moved their regional metrics in the right direction at the end of the reporting period. One of the other agents Reed mentioned Operation Metro Surge, Minnesota, a higher visibility assignment. His voice carried the easy envy of someone who felt he had been given the less interesting task. He said he wished they had been sent north instead of working the Texas heat for, in his phrasing, easy numbers. Vivian said nothing. She sat still. She let them speak. And with the trained retention of a nurse who had spent 10 years memorizing dosage codes, procedure sequences, and patient presentations under pressure, she began to construct a record inside her mind, phrase by phrase, in order, the exact texture of a conversation that would survive every challenge mounted against it 18 months later in a federal courtroom. The processing facility was cold and institutional in the specific way of spaces designed to disorient fluorescent lighting, linoleum floors, recycled air carrying the smell of industrial cleaner and old paperwork. Vivian was fingerprinted, photographed, and placed in a holding cell. She sat there for 2 hours and 42 minutes. She requested a phone call. She requested the supervising agent's name and badge number. She requested an attorney. She was told to wait. Each request was made calmly, clearly, and for the record. H1 hid. The agents, she observed, became progressively less comfortable as her credentials cleared through the system. The administrative certainty that had carried them across that parking lot began to shift not into acknowledgement, not into apology, but into the specific and recognizable discomfort of people who were starting to grasp the dimensions of a miscalculation they were not yet ready to name. She was released without explanation, without apology, without any formal accounting of the basis for her detention. Her belongings were returned in a plastic bag. She requested, again on the record, copies of all body camera footage and the incident report, and was given a contact number. She took a taxi to her mother's house. James and Jasmine were still awake when she arrived. James, 8 years old and generally too composed for open demonstrations of distress, ran to her in the hallway and pressed his face into her scrubs and held on with both arms. Jasmine wrapped herself around her mother's waist and did not let go for a long time. Vivian held them both on the floor of her mother's living room, still in her scrubs, the stethoscope finally off, her wrists still marked from the steel, and let them cry without offering explanations. She let the moment be exactly what it was. Later, after the children had fallen asleep on the couch, she sat down at the dining table under the single lamp and opened the notes application on her phone. She began to type. Every word from the parking lot. Every phrase from the front seat of the SUV, every timestamp she could reconstruct, the exact formation spread across the lot, the number of clicks, the name she had read on the store employee's badge, the badge numbers she had demanded and recorded on her way out of the facility. She typed until nearly 2 a.m. Her mother sat across the table as witness to a woman who had not been broken, only sharpened into something the 3 agents in that SUV had not imagined possible when they crossed a parking lot toward a tired nurse with groceries, and her children's voices in the back seat. When she set the phone down, she looked at the document on the screen. 11 pages, time-stamped, precise. The case had not yet begun. Vivian Benjamin had already started building it. She finished typing at 1:53 a.m. The timestamp sat at the top of every entry date, time, and the sequence of details she had held in her memory through 2 hours and 42 minutes of detention, through a taxi ride in the dark, through her children's arms around her waist. Her mother, Eleanor, signed the final page of the handwritten summary as a witness, a quiet, deliberate act at a dining table in the middle of the night that would survive every legal challenge mounted against it in the months ahead. The notes ran to 11 pages. Civil rights attorney Leonard Grant had spent 22 years taking cases that the institutional legal establishment preferred to file quietly and forget. His office on Westheimer Road was lined floor to ceiling with framed decisions, federal rulings, appellate opinions, confidential settlements whose amounts had never appeared in a press release because the opposing parties had paid specifically to prevent that. He had developed a capacity over 2 decades for reading evidence the way other people read weather, not what it showed on its surface, but what it meant for the days ahead. He read Vivian's documentation in one sitting. His expression shifted only once, a slight tightening around the jaw when he reached the section detailing the front seat conversation. The specific language about making the numbers work, the mention of certain neighborhoods as more productive for compliance operations, the reference to Operation Metro Surge, and the expressed wish that they had drawn that assignment instead of the Texas heat. He asked her one question before they discussed anything else, whether she was prepared for what a public trial would require, not legally, personally. She told him she had already considered it. Grant filed the lawsuit within the month. The claims were specific and documented unlawful detention without reasonable suspicion, violation of the Fourth Amendment right against unreasonable seizure, racial profiling in violation of federal civil rights statute, and intentional infliction of emotional distress. The defendants were named individually and in their official capacities: the United States Department of Homeland Security, Immigration and Customs Enforcement as an agency, and agents Derek Lang, Marcus Reed, and Tyler Quinn. The government's first response was not a legal filing. It arrived as a phone call to Grant's office, followed promptly by a written offer: $80,000, full confidentiality agreement, no admission of wrongdoing by any named party. Vivian read the offer at the same dining table where she had typed her notes. She considered it for exactly as long as it deserved. She told Grant her answer. The second offer came 6 weeks later, $275,000. The confidentiality language had expanded broader restrictions on public statements, on media appearances, on any future legal action arising from the incident or involving any of the individuals named. Vivian read it, considered it for 3 days, and declined. The third offer arrived after discovery had begun, $1.1 million. The figure was designed to feel decisive, large enough to signal that the government was treating the matter seriously, structured carefully enough that accepting it would prevent any public accounting of why it had been offered. Vivian sat with Grant for 2 hours, going through every clause. Then, she sat alone for another hour. She thought about the front seat of that SUV. She thought about what making the numbers work meant as a sustained operational policy. She thought about the families who had been through a version of that parking lot without a professional credential to offer, without a decade of clinical precision to apply to the retention of evidence, without Leonard Grant's phone number saved in their contacts, and who had accepted whatever the agency handed them because they had no other option. She declined. Do you think victims of racial profiling should accept confidential settlements to move on quietly, or fight publicly to expose systemic quotas? Drop fight publicly or settle quietly in the comments below and share why. Or share this video if you stand with families facing this kind of injustice. Discovery produced more than the defense had anticipated. Internal ICE field reports, obtained through compelled disclosure, revealed a pattern that Vivian's phone notes had described from the inside. Detention rates in minority neighborhoods across the Houston metropolitan region ran at 3 times the rate of demographically comparable areas elsewhere in the zone over a 14-month period. The disparity had been flagged internally by 2 separate field supervisors. It had not resulted in any policy adjustment. Vivian's timestamped documentation was submitted to forensic analysis and returned intact. Every entry matched the metadata. The content aligned with the internal field reports in specific and verifiable ways, not in the approximate, paraphrasable way of someone reconstructing a general impression, but in the precise, verbatim way of someone who had sat very still in the back of a federal vehicle and listened with professional concentration while the people in front of her said things they did not imagine would ever matter. They had talked because they had not imagined she was listening, the way a nurse listens with retention, with sequence, with the calm of someone whose work depends on remembering exactly what was said, in what order, and at what time. James began sleeping through the night again around the 3rd month. Jasmine's response to uniform figures resolved more slowly. Her therapist documented continued anxiety responses in structured sessions that extended through the end of the year, including unsolicited drawings of handcuffs and large dark vehicles that the therapist preserved and would later submit as part of the damages documentation. Vivian paid for the therapy sessions out of her salary, drove them to and from appointments between shifts, and returned home most evenings to find trial preparation materials spread across the dining table that had become the operational center of a case being built in the margins of a full-time nursing schedule. Community support arrived in forms she had not anticipated. Fellow nurses from Texas Children's submitted character statements. A vigil was organized outside the Kirby Drive, HEB, on the anniversary of the detention, small and quiet, attended by people who brought handwritten signs and stayed long after the formal gathering ended. Standing in the parking lot in the dark, as though bearing witness to a geography that deserved witnessing, local media picked up the story, then regional outlets. Vivian gave 2 interviews, both measured, both stripped of the kind of emotional display that invites reduction, precise instead, documented, anchored in the specific language of constitutional violation. She began meeting twice a month with a young woman named Dara, a nursing student from the 3rd Ward who had come to one of the community events and stayed to listen after the program ended. They met over coffee. Vivian talked about documentation, about knowing one's rights in the specific, practical, applicable sense, not as abstract principle but as behavior, what to say, in what order, for which audience, and why the body camera on an agent's vest is also a record that belongs to the person being filmed. Dara listened with the particular attention of someone collecting information she intended to use. The night before the trial opened, Vivian stood in the hallway outside her children's room and listened to them breathe in the quiet of the house. James had his arm thrown over his face the way he always slept, his body taking up considerably more of the mattress than it had a year ago. Jasmine had her blanket pulled up to her chin. Vivian stood in the doorway for a long time. Then she went to bed. In the morning, she drove to the federal courthouse in downtown Houston. The dining table behind her was clear for the first time in 11 months. The United States District Court for the Southern District of Texas was designed to project the weight of permanent things, high ceilings, marble floors, the specific acoustics of a room built to make what happens inside it feel consequential and irrevocable. On the morning the trial opened, every seat in the gallery was filled before the bailiff called the room to order. Activists and journalists occupied the rows behind the bar. Community members who had attended the vigil the previous autumn sat in the gallery alongside fellow nurses who had taken personal days to be present. The room had the particular quality of a space in which many people have arrived, understanding that something matters. Vivian Benjamin entered in a tailored charcoal suit, Her Texas nursing pin was affixed to the lapel, a small, deliberate choice that required no explanation. Her children were with her mother. Leonard Grant walked beside her, his briefcase carrying 11 months of work assembled at dining tables and in conference rooms, and in the margins of a nursing schedule that had not paused for any of it. The defense's opening statement argued routine federal compliance activity, good faith exercise of lawful authority, and the complete absence of racially motivated intent. The argument was professionally delivered and rested on a version of the parking lot that the footage did not support. Grant's opening statement was shorter. He played the body camera footage from all three agents simultaneously, on three screens positioned to face the jury directly. The parking lot appeared in synchronized angles, the tight formation, the flanking spread, the trunk still open, the bags on the asphalt. The moment Lang's hand closed around Vivian's wrist, while James's face appeared in the car window behind her, pressed close, his expression changing from confusion into something older and more frightened. Jasmine's palms flat against the glass. The courtroom held the footage in a silence that had nothing to do with procedure. Vivian took the stand on the third day. She described the shift, the school pickup, the errand, the stethoscope on the cup holder. She described the formation of the agents as they crossed the lot, and her immediate recognition of what it meant. She described the 4 clicks of the handcuffs and the angle of the hold. She described the front seat conversation in the SUV with the same sequential precision that had produced 11 pages of time-stamped documentation the night of the detention, the phrase about making numbers work, the language about certain neighborhoods as more productive for compliance operations, the reference to Operation Metro Surge, the expressed wish to have been sent to Minnesota instead. She quoted Agent Lang's words in the parking lot. She quoted them from memory. They matched the notes. The notes matched the internal field documents. The internal documents had been produced under court order and had not been anticipated by the defense when their own records corroborated a civilian's midnight phone entries in specific, verifiable detail. The cross-examination of Agent Derek Lang began the following morning. It did not proceed as the defense had planned. Medical records subpoenaed during the discovery process confirmed, in the specific and irrefutable language of institutional documentation, what Vivian's testimony described with quiet precision. 6 months before the parking lot detention, Derek Lang had been treated at Texas Children's Hospital for an on-duty shoulder injury in the emergency department. Her shift logs placed her on the floor. She had been his nurse. She had treated him as she treated every patient with professional care and complete competence, without any recorded deviation from standard practice, without any incident notation, without any indication that the man in the bed before her was anything other than a patient who required her attention and received it fully. 6 months later, he had led the approach across a Houston parking lot in tight formation, had dismissed her credentials without examination, and had applied handcuffs to the wrists of the woman who had cared for him while her children watched from a car window. The defense table went very still. The jury absorbed the information in a silence of a different quality than the one that had followed the body camera footage, not the silence of witnessing, but the silence of comprehension, of something settling into place that clarified everything that had been presented before it. Expert witnesses followed. A child psychologist presented the drawings James and Jasmine had produced in therapy, simple images, specific and unmistakable, rendered in the direct visual language of young children who do not yet have the vocabulary to say what they mean, and so draw it instead. Handcuffs, a large dark vehicle, a figure in blue scrubs with her arms behind her back. A constitutional law professor from the University of Houston detailed the Fourth Amendment violations with academic precision. No reasonable, articulable suspicion prior to the stop, no consent, credentials offered and refused, a detention duration that exceeded any lawful investigatory stop by more than 2 hours. The defense's closing argument invoked qualified immunity. Grant's closing argument returned, in its final minutes, to the image of 2 children pressing their faces against a car window in a parking lot on a Thursday afternoon while federal agents walked their mother away. The jury deliberated for 4 days. On the 4th day, the forewoman stood. The verdict was unanimous across every count. Unlawful detention, violation of the Fourth Amendment right against unreasonable seizure, racial profiling under federal civil rights statute, intentional infliction of emotional distress. The damages phase awarded $11.7 million compensatory damages, covering documented medical costs, lost wages, psychological treatment for both children, and the full costs of the litigation. and punitive damages assessed against both the individual agents and the agency itself, structured in the specific language of the judgment to signal that institutional tolerance of quota-driven, neighborhood-targeted racial profiling carried a financial consequence calibrated to be felt in future operational decisions. The courtroom did not erupt in the manner of theater. It shifted a controlled, sustained release of something that had been held at pressure for over a year. People stood. Some held each other. A woman in the third row, who had been at the parking lot vigil, pressed both hands over her mouth and kept them there. Vivian Benjamin sat at the plaintiff's table and looked at the jury. She thanked them without speaking, in the way people communicate across formal distance when language has reached its limit. At the defense table, Lang, Reed, and Quinn did not move. In the weeks that followed, all three agents were placed on administrative suspension pending internal review. ICE announced a regional policy examination and mandatory implicit bias training across the Houston field office. The case entered the legal record immediately cited in pending civil rights litigation across 3 other federal districts as precedent against quota-driven minority neighborhood targeting, the kind of citation that accrues slowly and compounds across years into a body of law that makes the next case easier to bring and harder to dismiss. Vivian's first decision about the award was not a personal one. She partnered with Leonard Grant to establish the Benjamin Justice Initiative, a pro bono civil rights practice embedded within his firm, funded in part by a designated portion of the judgment, focused specifically on victims of immigration enforcement profiling who could not otherwise sustain federal litigation. The initiative prioritized intake from families with young children, from healthcare workers, from individuals whose credentials had been dismissed in the way hers had been dismissed in a parking lot on a Thursday afternoon while their children watched. Dara, the nursing student from the 3rd Ward, joined the initiative's community outreach program. She trained volunteers to distribute Know Your Rights materials in English, Spanish, and Vietnamese across Houston neighborhoods. Other young lawyers arrived from law schools, from community organizations, from backgrounds that had given them direct fluency in the systems they were now being trained to challenge from the inside. The Benjamin Justice Initiative won cases. It won them methodically, with documentation, with the patient precision of people who understood that justice as method outlasts justice as spectacle. James and Jasmine grew up inside the legacy of that Thursday. At 15, James could describe what had happened to his mother in legal terms: unlawful detention, Fourth Amendment, reasonable, articulable suspicion, with the fluency of someone who had been given language to replace the memory of fear. At 13, Jasmine stood at a registration table at a community workshop her mother had helped organize, handing materials to families who arrived looking exactly as her family had looked on the evening of that afternoon in August, tired, ordinary, completely unsuspecting of what a parking lot could become. Years later, on an October evening when the humidity had finally released its grip on Houston and the air carried something approaching coolness, Vivian Benjamin pulled into the H-E-B marketplace on Kirby Drive. She had returned to the store many times since the trial. The first time had been deliberate, 2 weeks after the verdict, on purpose, because allowing the lot to carry a different weight than an ordinary parking lot would have been its own kind of concession to the 3 agents who had crossed it toward her. She loaded the last bag into the trunk. The asphalt was ordinary. The carts rattled in their familiar arcs. Someone near the entrance laughed at something on a phone. The afternoon light sat low and amber over the row of cars in the store's wide facade, the same light that had been there on a Thursday 14 months earlier when none of this had yet happened. She had not dismantled the agency. She had not ended racial profiling with a single verdict. She understood that with the same clinical clarity with which she understood the limits of any single intervention in a systemic condition. What she had done was make it more expensive in documented dollars, in cited precedent, in the specific and compounding consequence that now awaited agents and agencies who mistook a woman in scrubs for someone without the means or the will to answer them. Systems do not dismantle themselves. But one meticulously documented unbroken stand by an exhausted nurse finishing a Thursday shift can make them costlier. It can create precedent. It can fund a firm that fights the next case and the one after that. It can give a young woman from the 3rd Ward a reason to stand at a registration table and hand someone else the language they are going to need. The quietest compassion, it turns out, can forge the sharpest justice. Vivian closed the trunk and drove home.
If you like this video, make sure to hit that like button, subscribe, and turn on the notification bell so you don't miss the next story. Share this video with someone who would appreciate it, and let's keep building this community together. And before you go, drop a comment below. I'd love to hear your thoughts on what stood out to you the most. Until next time, stay safe, stay curious, and I'll see you in the next.
Accountability is a shared responsibility, and facts are your ultimate protection. We appreciate your time and commitment to verifiable truth.